Hello, I'm still Stephen Gold, the author of The Return of Breaking Law, the book What I Wrote. Small print, big subject. If you've made an agreement with a shop or other trader and one of the conditions is unfair, the law will strike that condition down. You won't be bound by it. That's in the 2015 Consumer Rights Act. If it looks unfair, it smells unfair, the probability is that it will be unfair under the law. Now, that doesn't apply to what you've agreed to pay. If you've committed yourself to shell out £49 for a pork pie, then you're stuck with the deal. But don't again shop on your own, please. And it doesn't generally apply where you're not a consumer, but you're running a business, unless we're talking about something which was for your private use as well as your business use, but the dominant purpose for buying was for the private bit, like a laptop, for example. So what about the poor business which is stuck with some pernicious condition it agreed to, perhaps stupidly? Is there no mercy for them? Well, that's where a case just decided by the High Court comes in. A company running the business of providing 800 carers to vulnerable people signed an order form for the supply of a mobile telephone service for 800 mobile phones. Then they cancelled the order before connection. The order form had referred to the supplier's terms and conditions, which could be accessed on its website. No, they didn't go to a website, did they? Had they done so, they would have found one page of closely spaced type, including an unheaded bit, which said that if the order was cancelled before connection, then the supplier could make an administration charge of £225 per connection. Now, for the mathematicians among you, 225 times 800 equals £180,000, which was way, way above what the supplier had lost out on. The supplier sued the company for that full £180,000. The judge said that this horrible condition had been cunningly concealed in the middle of dense thicket, was unduly onerous, and hadn't been drawn to the company's attention before it had signed up. Although the law normally resulted in anyone who signed a contract being bound by what it stated, whether or not they'd read the words, this didn't necessarily apply where the terms and conditions were to be found elsewhere, as here on a website, unless the signed contract had drawn attention to the nasty bit under attack. And that nasty bit was to be treated as not applying in this case. The entire claim for £180,000 was thrown out. There's been a development in county court home repossession cases. Among the temporary steps taken during the pandemic was the introduction of a scheme for review hearings. Instead of giving a date for the final hearing when the case was started, courts were asking parties to participate in a review, at which it was hoped that they would reach a settlement or there would be a mediation to take place later. The final hearing, if required, would occur another time. Well, this of course caused delay where there was no settlement. The scheme, alas, has been a flop, with relatively few settlements being reached. So it's been ditched. Landlords will rejoice, although it may survive at a handful of courts, although I doubt it. And the job of winding up the estate of somebody who dies after the end of this year gets easier where no inheritance tax is payable. In the majority of these cases, over 90% in fact, it will no longer be necessary to complete a long and painful form which goes off to the cuddly taxman, giving great detail of the assets and liabilities and any gifts made by the deceased in the period of 7 years before their death. Will you forgive me with sticking with death, or wills to be precise, just briefly? Some of us prefer to concentrate on the amazing skills of Ronaldo and why Aldershot Town football team is losing so many matches. But there are good reasons for making a will, and there are a load of ways that inheritance tax can be legally and morally avoided, as explained in my book. And in the book, you'll find the longest will in the world, with lots of different ideas which you can discuss with your solicitor if they're preparing your will. It does make sense to go to a professional, or stick in any will you're drawing up yourself. And a will is an ideal place to have a little bit of fun. After all, you want to provide for a party, don't you? My book suggests £2,000 to the executor to
spend on a party for such of my relatives who've sent me at least one birthday card in the period of 5 years immediately preceding the date of my death, and my friends, to be held in the public bar of the Black Death, Queen Street, Portsmouth, and at which there shall be a 2-minute silence in my memory. And should the party coincide with the television coverage of a Premier League football match being shown therein during the party, then the silence shall be respected in a commercial break of such coverage.
And you don't want any gift to be squandered?
I give the sum of £750 to my friend Mirabelle Myerson of 40 Gregson Arcade, Fareham, Hampshire, PO 16 7AA, on condition that at the date of my death she is not married and is not cohabiting with Greaser Gatry, and if such conditions shall not be satisfied, this gift shall fall into residue.
From Law Watch, don't botch, read my book.